Good afternoon.
Afternoon.
I'm here for a briefing on the Crystal Mason decision to appeal. Chandler emailed my office and asked if I would appear and give reasons why we're appealing that. And so I'm here. I'm going to give you a little outline of it, give you a little back history, and then we'll go. It's not a long briefing on my part. Happy to answer questions at the end. So this case started back in November of 2016, a general election. Mason voted in that general election, and on March of 2018, she was convicted of illegal voting, a second-degree felony, and she was sentenced to 5 years in the penitentiary. On May of 2018, the court denied Mason's motion for new trial. March of 2020, the Fort Worth Court of Appeals affirmed Mason's conviction. And then on March 27th of the same year, Mason's attorneys filed for a request with the Fort Worth Court of Appeals for an en-banc reconsideration, which was denied. On March 31st of 2021, the Court of Criminal Appeals, the highest court in Texas when you're just talking about criminal cases, the Court of Criminal Appeals, like the Supreme Court, Texas Supreme Court's for civil, Court of Criminal Appeals is for criminal. They granted Mason's petition for discretionary review, which means they petition, they don't have to hear every case that comes before them. You petition them and they decide whether they're going to hear the case. They decided to hear this case. And on May the 11th of 2022, this same court remanded that case back to the Fort Worth Court of Appeals and requested that they do a sufficiency review of the case. They'd already done one, but the Court of Criminal Appeals said you need to redo it. So they sent it back to the Fort Worth Court of Appeals, and on March of 2024, which was just 2 months ago on your calendar, the Fort Worth Court of Appeals reversed the trial court's judgment and rendered a judgment of acquittal. Now, this is the first action in this timeline that took place while I was DA. So all the other things happened prior to me becoming DA. I've only been DA for almost a year and a half. So March of this year was the first time that anything happened during my tenure. In April 25th to be exact, I filed a petition for discretionary review with the Court of Criminal Appeals because I'm concerned about what the Fort Worth Court did. So that's the basic history of this case. Started back in 2016. Here we are 6 years later, still in litigation. I want to go back to the Court of Criminal Appeals when they had the case. The Court of Criminal Appeals, as I told you, remanded the case back to the Fort Worth Court of Appeals. The Court of Criminal Appeals told the Fort Worth Court to perform a sufficiency analysis. Specifically, they told the court to determine if the state proved with sufficient evidence not only that Mason knew that she was on supervised release when she voted, but also that she actually realized that those circumstances, that the fact that she was on felony supervised release, that those circumstances rendered her ineligible to vote. A sufficiency review is not uncommon. The standard is well settled. It's something that courts do regularly. The appeals court in a sufficiency review, they are to look at the evidence, so they look back at the evidence, they're not in the light most favorable to the verdict. So they look back and say, okay, we know what the verdict was. The verdict was that she was found guilty. Now, is there sufficient evidence to support that verdict? But that's not what happened in the Second Court of Appeals this past March. Instead, the court reweighed the evidence. They acted like a fact finder. I like that piece of evidence. I'll take that. I don't believe that piece of evidence. I'm going to push it away. That's not what you do in a sufficiency standard. They credited and discredited evidence just like they were the fact finder. This is not a fact question. We are not here to talk about facts. This is a legal question, a matter of legal principle, sufficiency of the evidence. Their decision was a deviation from well-settled law on sufficiency reviews. So why is the state, why am I appealing this case? Well, I'll give you 3 reasons. Number 1, I want would-be illegal voters to know that we're watching and that we'll follow the law and we will prosecute illegal voting. I want those that vote legally to know that we're watching and that we're working to make sure that your vote's not going to be diluted by any illegal votes. And finally, this is a deviation from the well-settled law regarding sufficiency reviews, and it needs to be corrected. This case, if it's left standing, impacts every sufficiency case in the state of Texas, not just voting cases, murder cases, theft cases, capital murder cases. Any kind of case, this case, it's a published opinion, can be cited for a proposition that this is how you review sufficiency cases, and it's wrong. So we need the Court of Criminal Appeals to come in and tell the Second Court of Appeals that you need to do the sufficiency standard evaluation again. Happy to answer any of your questions.
Questions for Mr. Sorrell?
I have a bunch, but I'll wait until after public comment. But let me ask you this. How she did not vote. She submitted a provisional ballot.
One moment. I keep hearing chatter in the audience. I'm going to start watching and start removing people. That's not what we're going to do. So sit there, let the process play out. You'll have your opportunity to speak. Listen to what others are saying. Do not speak out or you'll be removed from the chambers. Go ahead.
So she didn't vote.
She did vote. She cast a provisional ballot, which is the same with voting.
That did not count. Where is the ballot, sir? What happened to the ballot?
I can't tell you what happened to
What
the ballot.
do they do with provisional
I'm not the elections
ballot?
administrator, so I don't know where the ballot is, no.
Chandler, do you know what they do with provisional ballots?
Not
No.
right now, ma'am. I don't know. My
Okay.
apologies.
It didn't count. Is that correct?
You're wrong. The Court of Criminal Appeals dispelled that quickly and said this was a vote. The question was not did she vote, it was did she actually realize that while she was on felony supervised supervision that she wasn't allowed to vote.
Okay, so the ballot was never cured, so it wasn't counted, so she didn't vote. How else
She did vote.
How else does the Court of Appeals weigh the sufficiency of the evidence without weighing the evidence?
They look at the evidence most favorable to the verdict. So they're not trying to figure out did they get it right. They look to see if there's evidence. So you find your conclusion in an argument. They have a conclusion, guilty of the offense. So now they're going to look and see, is there evidence that supports that? Now, a normal trier of fact would say, look, this person testified and I don't believe anything they had to say. Or this person testified, I believe everything they had to say. Or you have another witness that says, I believe some of it, but part of that doesn't ring true. That's what a trier of fact does. That's not what an appellate court does. An appellate court looks at the law, not the facts. They're not the fact finder.
Okay, I have other questions, but I'll do it after the public
All right,
comment
so
session.
again, I'm going to call out 3 to 4 people at a time.
You're finished with me?
So, well, here's the deal. That's your choice. So, do you want to
Well,
stay
if you
here?
don't have any questions for me, I'm happy to stay. I need to get back down to my office.
Yes.
I'll have other comments and questions. You don't have time to wait until the public
I've
comment
been here
session.
since 10 o'clock. I need to get back to my office. If
Okay.
you have questions for me, I'm
So
happy to
I'll
answer
go.
them now.
So what I, from
Who
what I understand,
who made the noise right over there? Which one?
From
Okay, we're not going to do this. Was it which one on this row? Okay, we're not doing this. Okay, we're not doing this. If we need to clear the whole chambers, we can do that. But we're not going to sit there and do this back and forth. Okay, go ahead.
So, thank you. From what I understand, the merits of the case really hinge on whether or not Ms. Mason understood or didn't understand legalistic language on the provisional ballot that may or may not have said she wasn't eligible to vote.
Well, the testimony-
I'm not a lawyer, so I don't want to get bogged down today on those details as they seem. more fit for a true courtroom, and you could probably best me up here. But what I guess I'm most interested in Judge Sorrell.
Well, the question that you had there is, did she know that it was confusing? She testified at the trial court and said, and she read it, and she said, no, it's not confusing. I understand by reading this, I'm not eligible to vote. That's the testimony.
I understand that's your position.
Well, it's not my position, it's the trial court's position.
Okay, and so it concerns me that nobody knows or you don't know what happened to that ballot after Ms. Mason cast it. It was not counted. So, all right. So to summarize, the ballot probably got tossed and had zero impact on the election. Is that right? What type of impact did it have on the election?
I can't answer that question because I don't know the answer. I only know about what's happening on this appeal.
Okay.
What happened back in 2018, or 2016 actually, was when this election, when the ballot was cast. What happened to it, I can't tell you.
All right. So let's go here. Now, last month, county administration circulated a judicial dashboard that outlined the case backlog in each court. It is my understanding that this case will be reheard in Judge Gonzalez's 432nd District Court. No?
No.
Okay.
If my petition is granted, it'll be heard by the Court of Criminal Appeals.
Okay.
They'll make the determination. It won't impact the trial court. The
Okay.
trial has already happened. The facts have already been set long ago before you and I were elected. The facts of this case, the die has been cast.
Okay. So let me ask you this. Talk to me about the resources it would take here in this county from your office in terms of personnel to appeal a case like this.
Any kind of case?
This case.
Well, this case, we have one attorney that wrote the PDR. He has multiple things that he does, but when the decision came down from the Fort Worth Court of Appeals, he's the one that had been handling this case he didn't start with the case. Somebody that doesn't currently work in the office first wrote an opinion on this case, and so I have one attorney that worked on it.
Okay.
Other people reviewed it because they're going to do like a peer review. They're going to look at, when you write an opinion, or write a brief, you're going to give it to somebody else and say, does this make sense? Are there errors in it, like typos? Does the reasoning make sense?
So you're going to have how many staff work on this case, this appeal?
I'm going to tell you one.
One. Okay. And so that's all that we can expect of taxpayer dollars to be expended on this case, on this appeal.
I don't know that you can say that only one person. So if you want to take somebody's salary, I'm not really sure what you're trying to get at. You're trying to say that
How much in taxpayer dollars will be expended on appealing this case? The Second Court of Appeals has already acquitted her. What are we
they
doing?
didn't acquit her. They ordered an acquittal. She was adjudged guilty at the trial court. The case, how many hours have been spent? A lot. We've been defending this verdict for years against her lawyers. So we're in the position of defending this case until 2024. Now we're in the position on the opposite side for the first time.
Is there not anything else? Do you not have more pressing cases to deal with to get people out of this overcrowded jail?
I have a lot of cases that I deal with, people in and out of jail, people on appeal. We can handle them. That's what we do.
And so I mentioned Judge Gonzalez, and you corrected me, but I still want to use that as his court as an example, because as of April 1st, the dashboard notes that Judge Gonzalez had 397 settable cases, with the defendant currently sitting and waiting for trial in the Tarrant County Jail. That's a lot of cases for one judge. And so we've got those people sitting in jail. I still contend this Mason appeal is a waste of taxpayer dollars. a waste of time. We've got other cases that we could be moving through the system. So that's all I have for now. Hopefully you can stick around. You know what? I will tell you, I appreciate you for showing up, because the sheriff damn sure did. Thank you.
Any other questions for Mr. Sorrells?
Thank you, Judge.
Thank you. Appreciate you being here. All right, so we have several speakers signed up for this. I'll read probably